And so what we aim to do at Her Justice is kind of with that kind of statistical realities, how is that consistent with what we know about poverty? So if you look at this demographic, it kind of gives you a breakdown of the clients that we have. And what is unsurprising is that most of our clients are women of color, given the US's history of systemic racism and what that has meant that people of color are disproportionately living in poverty. It's also unsurprising that we have so many immigrant clients, given the barriers that immigrants face to economic security, which includes language, discrimination, and the different aspects of the immigration system. So one being the long time it can take to get a work permit. The next thing that we'll look at is that this is more in line with the type of immigration relief that we're talking about today, is that 75% of our clients are survivors of intimate partner violence, and that's also shortened sometimes to IPV. So if you hear me refer to that later on, that's what I'm talking about. And so what does that mean? So if you look at this, it's called a power and control wheel, and it kind of describes the pattern of coercive and abusive behaviors that are used in relationships to maintain power and control over the other partner. And the goal is basically that there is a fixed imbalance of power depending on the type of abuse. It could be a combination of all of them. Some we want you guys to understand is that it's not just one incident, it's usually a pattern, and that one incident of physical violence and constant emotional and verbal abuse, it all is tied together. And so some forms of abuse are not widely understood to be IPV, and so it's not surprising that survivors may not recognize some of the things that have been done to them as IPV. So if you're working with a client and they are talking to you about, oh, it was just an isolated event, but they also didn't let me access the bank account. I had to ask for money each time. And that it was just one time that their partner was abusive. It's really kind of being able to talk to your client and understand all the different parts of this wheel and how they're all connected to each other. And so it also kind of ties into the myth of like, why didn't you just leave after that first physical incident? And it's because there's a lot of other parts that are connected to that. So they may have children in common. They may be dependent on that abuser for economic support, housing. They're all of these types of acts they're all connected. And so this wheel just kind of demonstrates the different ways and how they're all connected. And so as a result, there's a connection between IPV and trauma, but clients may also experience trauma from other areas of their lives. So just because they have an isolated trauma from an IPV doesn't mean that there are other circumstances that they experienced physically or emotionally that are harmful and threatening, and that they all have long-lasting adverse effects on the client's functioning, their physical and emotional well-being, and these are all effects of trauma. So how does trauma impact your client? There are real and powerful ways that you will be able to see of how each client has been affected by the trauma. There sometimes it's not rare. It's not it's that you can see that a client may have difficulty recalling what you might think are pretty important details of their lives, and how could they not remember every single thing that's happened. And so this is really common because often certain things. And so they may not recall the details when you're trying to work with them to get details for your affidavit. They may not be able to recall things in like a linear timeline, how somebody that has not been a victim of trauma can. So it's kind of learning how to notice that, you know, that there's a range of emotions that go into interviewing your client, and kind of being able to pull the information that you need from them. And so here is kind of like some things to keep in mind when you're working with trauma survivors. The most important is that you are patient and non-judgmental, so that sometimes you may need to reframe questions to get them to understand what you're asking, because you are working in a mindset of you need certain information to fill out the forms that they need to file for their U visa, or you need certain information to write their affidavit. But it's important to kind of acknowledge and validate emotions that are involved in this. It's not simply filling out biographic information, it's recalling details of trauma and probably some of the worst experiences in their lives, and acknowledge that, you know, even yourself, it may bring up a lot of emotions and things that you may have not been expecting. And so it's important that when you're working with these clients, and also for yourself, to take breaks. And it's easier to schedule shorter appointments when you're working on this, because to talk for an extended period of time about these traumatic incidents, it's difficult and exhausting. And also, especially now that we're going to be working remotely with clients, kind of that disconnect of not speaking with the person in front of you, to kind of manage that in your appointments when you're meeting with your clients. Another thing is that if you see them struggling or really having issues with talking about these things, that you can connect them with other supportive resources, and kind of also managing with them the expectations of what you are going to be working on them with. So if you feel like they're really struggling, you can reach out to the mentor that you're working with from Her Justice and let them know that you think that they would benefit, and kind of work with them to find them the resources that ultimately will help you work on your case better. And also to remember to take care of yourself, because working with clients that have experienced trauma is really difficult, especially if it's something new that you are working with on the. Is reach out to your Her Justice mentor and connect yourself and clients with other resources. We also have a link here to a Her Justice video that you guys can look at later on, that talks a little bit more in depth of working with clients with IPV. And then this is kind of something new that everybody, as a result of what's going on in the world, is kind of working through. I think that either way, whether you are working in person or remotely, it's really important to come up with a plan together with your clients so that they have an understanding of what you're going to be working on at the appointment when you set it with them, so that they can prepare themselves for the work that they will have to do, or at least be expecting the discussion, the types of discussions that you're going to be having. Specific to remote work, I think the first thing you should do is have a discussion with your client on the best time, the best way that you guys will be meeting, and determine what you feel comfortable with and what they feel comfortable with, and how the best way that you prefer to be contacted by them. And in doing this, it's kind of also setting boundaries and expectations for the type of communications that you feel safe with and they feel safe with. The other thing to understand is, you know, to remember to be patient and flexible, because they may not have the ability to have a room that they can talk to uninterrupted. So if they have children or family members living with them, to kind of be patient in that it won't be a typical appointment like meeting in your office. And so to just keep that in mind, that it may take longer to do some of the things that should take one appointment in theory. And that, it may mean that they don't have like a quiet place to listen to you, and that you may have to explain or repeat yourself more than once. And also to remember to stay aware of what's going on with your client, with everything that's going on. Things can change in their lives very quickly: housing issues, work issues, health concerns, and that, don't assume that you know what's going on with them, and to make sure to check in at some point when you have your appointments with them. The next thing is to kind of what we discussed a little bit already, but prioritize self-care, and that you can't work for 4 hours on understanding that you may not know what's the next step in the client's life, or that things are kind of not that things are uncertain, and that you have peers and supervisors to reach out to for support, and also be aware of your own emotional capacity to be present for your clients. Oftentimes a client will look to you as their attorney and think that you can help them with many aspects of their life because of kind of the dynamic, which we'll get into in a little bit, but that you are there and they see you as a problem solver for many aspects of their lives, and that you need to be, set boundaries so that you can protect yourself, and also help them with the case that you're working with them on. And you'll see in the manual, in your Her Justice manual, we'll refer to that a lot, that there's a lot of tips and kind of information about working remotely with your client and how to do this. So the next thing you'll see is that, like what I was just saying about the dynamics of you as the attorney and your client. And so, we talk about the resilience and strength of our clients a lot. And it's sometimes we see it as a victory that they're even here seeking services, because there's a lot of work that goes into getting access to legal services, whether it be them recognizing that they want to get help, and then also that even in New York City, it's hard to access legal services, especially free legal services, and that they may have met with a few different agencies before they were able to get placed with an attorney, that they may have already discussed their story with multiple people, and ultimately had many of those appointments fall through, and that by the time they have gotten to you and to working with you, that they've been through a lot in just trying to access legal services. And so it shows a level of resilience and strength that they were able to persevere and get access to legal services. And that, a lot of them are dealing with high stress, urgent life issues beyond their Her Justice case. And that they also are likely to have very little knowledge of the legal processes, the court systems, the immigration systems, and so they will look to you for a lot from what they think that they are going to be able to get from you. And that to this area of law, that you may not always have the answers, and you can explain that to them, but that you are there to try to help them as best you can, and that even if you don't have the answers, you will be able to access through your mentor different resources for them. Okay. And then, so just to refer back to the manual, there's a lot of helpful information about working with pro bono clients, working through this COVID-19 situation, and other free services for clients during COVID-19, and that you can always reach out to her justice mentor. And we also have a social worker on staff if you feel that you need more assistance with what your client is asking you for. Okay. So now what we'll do is go over kind of the systems and process in immigration. And so the first is kind of to understand the administrative structure. The overall agency is what we call Department of Homeland Security, so DHS. And under that are three of the main agencies for what you'll hear in the news and what your clients may say to you, are the three main agencies for under DHS. The first is Customs and Border Protection. So these are the officers that you will have contact, that you may have had contact with when you re-enter the US from abroad. And so what we will sometimes call them is, their shorthand is CBP. The second is the main agency that that you will be working with in terms of your U visa application, and that's the Citizenship and Immigration Services. So they're called CIS or USCIS for short. And the third, which is in the news a lot, is Immigration and Customs Enforcement, ICE. And so those are the police immigration officers that mainly deal with like at the border, US-Mexico border. You'll hear about like raids and things like that, and those are the officers that when they say ICE. These are the main authorities for immigration law and how we what policies and things are set forth in immigration. So the first is the Immigration and Nationality Act, which is short form what we refer to as the INA, and we'll talk about that later on when it comes to something that's called inadmissibilities. This short form is 8 CFR. The other body of law is Administrative Decisions from the Board of Immigration Appeals, BIA, and the Administrative Appeals Office, the AAO, and they will issue rulings that determine that makes another body of immigration law. The fourth is federal court decisions. And the last, which applies to USCIS more often than not, is the agency memoranda, where they will issue policy memos and things like that, kind of clarifying different requirements or policies that they have for different types of immigration relief. And so these here are the main ways to obtain lawful status: through a family member, through an employer petitioning for you, through something called visa lottery, which applies to like underrepresented countries. They have a lottery for visas to award. And then the main area that we work with at Her Justice is under humanitarian applications. So these are what you may hear like VAWA self-petitions, U visas, trafficking victim visas, the main area that we and our clients qualify for. And so examples of immigration status are, there's basically three categories: non-immigrant, which can be somebody that's here on a student visa, a tourist visa, a temporary work visa, and it basically is a limited authorized stay. So you are here for a certain period under certain restrictions. The second category is immigration status, and that's lawful permanent residents, so green card holders. And then the final category is if you're a citizen, and you can be a citizen through being born in the US, applying for citizenship, naturalization, and if you acquire or derive it through parents, and there are different requirements for each of those. The next main thing that usually determines what kind of relief you may be eligible for is how you come to the US. So what if you had a tourist visa and you enter through an airport or at the border and you have a valid tourist visa, that's called entering with inspection. And basically, it means that you have a wider, once you're here in the US, there's a wider possibility of getting immigration status because you don't have to, you entered with inspection. So being stopped by immigration, you get usually an I-94 that people that enter without inspection. So based on that, you have a limited type of status that you may be eligible for. And so usually if you're a non-immigrant, you may have had to apply for to waive that entry without inspection. And so we'll talk about that later on, but that's kind of the two types of entries into the US. The next thing that you may hear your clients talk a lot about is executive orders. So what is an executive order, or what do they say? Usually what they do is create enforcement priorities, which means that, depending on the order, they may choose to prioritize people with criminal convictions or charges, or anybody that is engaged in fraud or willful misrepresentation, in terms of prioritizing those people to remove from the US. We don't always know how these orders will be implemented because Congress needs to appropriate resources to carry out these orders. Mainly, our clients will hear about this through rumors in their community, and kind of hearing about raids or people being arrested. And so if you are hearing kind of concerns about these things from your clients, to make sure to check in with your mentor to know whether these allegations are true. Often or not, they're not true, and they're just rumors that people have heard, and they create fear in the communities that we serve. But that, and mostly it's what we advise our clients is that anyone who's already known to immigration authorities is at risk, and that filing a U visa does not increase that risk. It can only provide a protection. But that that victims, you petitioners, have been protected by the government, and that we want to advise them not to of ways to protect themselves against an ICE raid and things like that. And again, you should reach out to her justice mentor for those materials. Okay, so next I'm gonna give you kind of a client story to keep in mind when we're talking about a U visa and the different requirements. So I'm gonna read this out loud to you and just keep it in mind as we talk through some of the steps. So this is Gladys, our client. She was born in a small rural village in Puebla, Mexico, as the third. Was sexually assaulted at the age of 14, but did not tell her parents because she was ashamed. She quit school and started working when she was 15 to help support her family. She became pregnant at the age of 16 and gave birth to a baby. Her sisters and mother helped raise her son. At the age of 21, her family was struggling. They did not have enough to eat. Many people in her village were traveling to the US to work and send money home to support their families. Gladys decided to do this temporarily in order to provide for her family. She had a cousin in New York who told her that she could stay with her and work. When she was 22, Gladys made the 3-month journey by bus, train, and foot to the US. Her son stayed behind in Mexico. Her family helped her pay a smuggler to help her cross the border. When she got to the US border, the group she was with was apprehended by US officials. They were fingerprinted and turned back to Mexico. The next day, the group set out to cross the border again and were successful. Gladys made her way to Queens, New York to find her cousin. Once settled in Queens, Gladys moved in with her cousin Marta, who helped her get a job. The apartment was crowded and uncomfortable, but Gladys was happy for a place to stay. She cleaned houses with Martha and was paid in cash every week. She sent most of the money to her family in Mexico and used the rest to support her living expenses. At a party one night, Gladys met Miguel. He was charming and sweet and invited her to the park and to the movies after work. After a few months, he asked her to move in with him, which she did. In 2011, she became pregnant with his child, and things began to change. Miguel became very controlling and possessive. He told Gladys to stop working. He told her that she could not leave the apartment without him, and he took her keys away. He refused to give her money so that she had to rely on him to buy her food, which he only did if she begged him. Sometimes he made her have sex with him before he would allow her to have food. One night, she told him that she couldn't stand to live this way and that she was not getting enough nutrition for the pregnancy. He smacked her across the face and told her that he is the man and she had to listen to him. He also told her that if she ever tells anyone or goes to the police, she would be deported since she is illegal. She was ashamed of being undocumented. She only spoke Spanish and did not have anyone to talk to about this, so she believed him. Gladys prayed that the situation would change once the baby was born. She gave birth to her daughter in 2012, and Miguel continued to abuse her, but he did allow her to take the baby to the doctor. At one of her daughter's medical checkups, a nurse noticed a bruise on Gladys's arm and asked her about it. She was tearful but too afraid to tell the truth. She lied and said she bumped into something, when the truth was that Miguel had grabbed her forcefully and pushed her down on the floor. The nurse gave Gladys a few pamphlets about nursing and also put up a pamphlet about domestic violence in the packet. When Gladys got home, she read it and she quickly threw it away so that Miguel wouldn't find it. About 2 weeks later, Miguel punched Gladys in the ribs when she refused to have sex with him. The baby was next to her on the bed when this happened, and she was terrified that something would happen to the baby. She was in pain, and 2 days later, there were large bruises. Gladys remembered the nurse and went back to the hospital. The nurse called the Administration for Children's Services, or short, ACS, and they interviewed Gladys. They reassured her that telling them what happened would not get her deported and would actually help her get immigration, or could help her get immigration. They told her that she did not have to stay with Miguel, and they helped her get into a domestic violence shelter. She did not return home. They told Gladys that she could make a police report, which she did. Miguel was arrested and prosecuted. Gladys met with the district attorney and received an order of protection. Gladys is happy to be out of the situation, but she is upset that her daughter's father is now out of her life. She is also very nervous about her immigration status. After all of this, she does not want to go back to Mexico. So using Gladys as the case example, we're going to go into a little bit about the U non-immigrant status history and its purpose. So the U, we'll call it U visa for short. The U visa was created with the Battered Immigrant Women Protection Act of 2000. And so the intent of the legislative intent behind this is to strengthen law enforcement. And so essentially, what they wanted to do was encourage immigrant victims to report crimes, because they were seeing that if victims were undocumented, they were less likely to report crimes and to speak out against the person or the people that they were victimized by. And what they wanted to do was protect these victims who have suffered substantial or physical abuse as a result of the crimes, and also strengthen law enforcement's ability to investigate, prosecute crimes such as domestic violence, sexual assault, trafficking, and other crimes. And so what is U non-immigrant status? So when your U visa is approved, what it means is that you have a temporary status that's valid for 4 years. And it allows non-citizen victims of crimes to, one, stay in the US, get work authorization, and help certain family members, which are called derivatives, obtain status. It also provides a path to applying for lawful permanent resident status, which is a green card. And there is a statutory cap set on U visas for 10,000 per year. And this is reset every October. There are 10,000 visas issued. But the 10,000 cap excludes derivative beneficiaries. It's only for principal applicants. And so what kind of are the benefits and limitations of this type of relief? The benefits are that it may provide people with no other immigration possibilities a path to a green card. If you're granted non-immigrant status, after apply for your green card. At some point during the pendency of your application, you're granted a work permit, which can be renewed until there's a decision on your application. And often the most important for our clients is that it offers them an opportunity for family reunification once their U visa is granted. The limits or kind of the downside to this type of relief is that the main downside is the statutory cap, in that these applications take quite a long time because the cap of the 10,000 visas has been reached, and they're currently processing cases from around the end of 2015 to early 2016. And so the time waiting for a decision on that case can be at least 3 years, possibly longer, since we don't necessarily know how long USCIS will take to adjudicate this. During the time that the case is pending, and also while they have non-immigrant status, we really discourage overseas travel. And also during the time that the case is pending, there is no reunification with children abroad when you're granted what's called deferred action while your case is still pending. And also, you can't petition for the perpetrator of the crime. So that's not necessarily negative, but it's a limitation on the relief. So you may have heard me, I referred to something called deferred action, which is a little bit different than DACA deferred action. It basically means that USCIS will make a determination at some point while the case has been pending that all the eligibility requirements have been met, but the 10,000 visa statutory cap has been reached. And so they'll place you on a waiting list called deferred action until there is a visa available. During this time period, the whole time the case was pending, you wouldn't have been eligible for a work permit, but once you are placed on deferred action, you're eligible for an employment authorization document, which is we call an EAD. That EAD is valid for about 2 years and can be renewed depending on if there has been no visa number available during the time period you're on deferred action. Just check. There's no questions. Okay. The limitations of deferred action are that there currently is no process for something called advanced emergency and then being able to re-enter. There's no process for that. That, like I said before, that derivatives abroad are not able to reunite while the principal petitioner is on a wait list, and that you must renew your work permit until your U visa is granted. Okay, so now we'll talk about the different elements and how to determine eligibility for non-immigrant status. The first is that you are a victim of a qualifying criminal activity. This means that you suffered substantial physical or mental abuse as a result of being a victim of a qualifying crime, that you possess information about this criminal activity so that you have information to report to a law enforcement agency, that you were helpful to the law enforcement agency in the investigation or prosecution of the crime, that crime occurred in the US or violated US laws, and that you suffered substantial physical or mental abuse as a result of the qualifying crime. And what I like to look at these, the way these are broken out, is how I would structure the client's affidavits so that you make sure that in her statement, she describes each of these elements. So the first is, who is a victim of a qualifying criminal activity? So if you're a direct victim, that means you were directly or directly harmed. There can also be indirect victims. So if you were an individual helping to investigate or prosecute a crime when the direct victim could not. So for example, the most common is if your child was a victim of a crime, they're too young or unable to assist in an investigation. As a parent, you can be an indirect victim and help when the crime. And also bystander, which is a witness who suffers unusually direct harm. The most common in our cases are direct victims. The next is, what is a qualifying criminal activity? So if you look on the actual form for the U visa, which is we'll go over later on, it's called an I-918. It lists all the possible qualifying criminal activities. The main one that we work with are the qualifying crime of domestic violence, sexual assault, felony assault, kidnapping, and then attempts, conspiracy, solicitation to commit a qualifying crime, or any similar activity in violation of federal, state, or local law. And so again, we see how this ties into the power and control wheel that we looked at before. So using Gladys's example, we can see maybe some of the facts of the hypo were that she lived with Michael for 2 years, and they had a child together that at the time she reported the incident was about, I think maybe like 5. Michael threatened to have her deported if she reported his crimes to a police officer or a law enforcement agency. So those are like intimidation. He also paid the rent and earned more than she did. She worked off the books and earned in cash, and he demanded that she give her the cash that she earned so that, you know, she was beholden to him for an economic support. And that he kind of monitored her ability to speak with her family and kind of made fun of her or intimidated her about her only speaking Spanish. So you can see how all of the different types of intimidation and abuse, all the different types of power and control, how they are all tied together in this wheel. The next, we'll talk about the two, they kind of group together, about possessing information about criminal activity and helpfulness to law enforcement. What constitutes a law enforcement agency? So there are law enforcement agencies that fall under federal, state, or local law enforcement agencies. So it can be the prosecutor, a judge in family court, a police department, or any other agency tasked to investigate qualifying crimes or similar criminal activity. And what they need to do to show like that they have information or helpfulness is knowledge or specific facts that would assist in the investigation or prosecution of a crime. There's no unreasonable refusal to cooperate, and helpfulness. And the way that we determine this is there's a form called an I-918B, which is a law enforcement certification that we ask the law enforcement agencies to sign and that document shows these two elements. It's if you are placed a U visa case, the client will already have a signed I-918B, and that document it establishes that they had knowledge and that they were helpful with an investigation or prosecution. And it has a letter of designation of authority that states that that agency is able to sign that form. The important thing to note is that the cert, we call it for short, the cert is valid for only 6 months from the date it was signed. So that means that your client's case has to be submitted and received by USCIS, by immigration, within 6 months of that date. So let's look again at Gladys's case. Who, and this is going to be a polling question, who might the law enforcement agencies be in her case? We have the NYPD, ACS, the DA's office, or all of the above. Just give a couple more seconds for a few more people to respond. Okay, yeah, so it is all of the above because she had contact with and reported her case to the police. She met with ACS, and also she met with the officials from the DA's office. So all of those agencies are possibilities to request a law enforcement cert in her case. This here is an example of a 918B, so the law enforcement cert. And you can see here under part 3, it's on page 2 of the actual form. These list out all the possible crimes, qualifying crimes. In this client's case, it was certified by the Queens DA to domestic violence. You'll also see here that the requirement for helpfulness of the victim and how this goes to that element of the crime, and that from that part 6 on page 4, it lists the certifying official's signature and the date that they signed the form, and that's the date that you use for the 6 months filing deadline. Okay. So we'll move on to the next element, which is that the crime occurred in the US or violated US laws. This is pretty self-explanatory in that on the 918B, it'll say where the crime occurred, and so that's just something that you just state in your affidavit that, you know, where the client was when she called for help, or that where the case occurred. Okay. And then the next question. Okay. The main next point, which is kind of the substance of the affidavit that you'll be working on to get information from your client, is the element for substantial physical or mental abuse as a result of the qualifying crime. And so what this basically is you need to get from your client information to describe kind of the nature of any injuries that she may have received, kind of the severity of what happened, how long it happened, the pattern of the abuse. So kind of if you look at Gladys's case example, that she was with her partner for 2 or 3 years, they had a child together, and kind of any sort of pre-existing conditions that she may have been victimized by, and it basically is it's her opportunity to tell the story of what happened to her and describe that, you know, the cert might be for one isolated incident when she called the police, but that there may have been 4 or 5 or 6 or however many, um, you know, violent incidents or abusive incidents prior to that, and kind of give the pattern to show why mental abuse. And so what evidence can you use to show this? The main thing, like I've talked about, is her sworn statement, her affidavit. She may have medical records. So in Gladys's case, she was in the hospital, or she went to a medical office. You may be able to help the client request hospital records, or if she was taken by an EMT. Another helpful type of evidence is letters from medical or mental health professionals. So sometimes clients will be seeking therapy and they may be working with a counselor that can provide a letter describing what type of services the client is getting. Police reports, orders of protection, and affidavits from supporting affiants. So if there was ever an incident with a family member there or a friend, like that can corroborate some of the information. Those are helpful types of additional evidence. And so,
Hi, sorry, not to jump in real quick. Just reciting the CLE code for those who are viewing this after the fact and getting CLE credit. The code is ER404. Again, that's ER404. Sorry.
thanks, Mike. And so some practice tips for getting this evidence, or establishing this requirement, is to, like I said, get as much information you can to show that it was a pattern of abuse, the different types of behaviors or control mechanisms that the abuser used, and also address, the main thing to address in addition to the pattern of behavior is the crime that was certified by the law enforcement agency, and to also describe the abuse from each incident of domestic violence and the cumulative harm to the client. The next thing that we'll talk about is the types of the forms that you'll be working with your client on. So here is an example of the form for the U visa application that is sent to USCIS, and it's called an I-918. And you'll see on here some this is just the first page, but the manual, your Her Justice manual, will have detailed samples and detailed instructions on the questions and different things that you'll need to get from your client. If you have any questions about any of the way the questions are worded, oftentimes they're a little confusing, even in English, and you're not sure, make sure you reach out to your Her Justice mentor. There's also, this is a little graphic from one of my favorite Instagram accounts, which is like, it's called a Burned Out Immigration Attorney. There has been a new advisory about blank spaces on the 918. And you'll see that entire advisory in your Her Justice manual, but there are certain parts of the application that may not be applicable in your client's case. And to make sure to write in or put NA or write not applicable in those cases. And again, if you have questions about this, to make sure to reach out to your Her Justice mentor. But that all of that is in your manual, and the information and samples are all provided in there. Okay, so to recap the elements of the U visa, or what you need to show to show that you qualify, is that the aliens, the client suffered substantial physical or mental abuse as a result of being a victim of a qualifying crime, and also that she is not inadmissible. So what does that mean? Inadmissible, I've used that a couple times already. And depending on your client's background information, they may have to file, in addition to the I-918, another type of form if you determine them to be not inadmissible, which is a confusing term, but basically it means that that there's a reason that they may require a waiver. And so these listed here are some of the more common grounds of what's called an inadmissibility under the INA Section 212A, and that could be being present in the US without admission. So like I described before, the two different ways to enter the US. If they entered with a visa, a tourist visa, and overstayed, that would mean that they were inspected, and so they were admitted into the US. If you have a client that entered through the border without a visa, without inspection, they would be present in the US without admission, and they would require a waiver. Certain criminal convictions may make your client inadmissible if they don't have a valid passport, which is a requirement for a U visa. They may need to file for a waiver of that inadmissibility. If there were any fraud or material misrepresentation used to obtain a visa, they would may potentially need to file for a waiver. If they've ever claimed to be a US citizen before, if they've had prior contact with the immigration system, so if they've ever been removed, and also if they've accrued any unlawful presence, which is after a certain time period of being in the US without authorization or without admission, and whether that's been triggered by leaving the country and re-entering, or if they're subject to what's called a permanent bar after leaving the US with unlawful presence and re-entering. Again, all of this is described in the manual, and if it would be outlined for your client if they trigger any of these inadmissibilities. However, if you, in talking to your client, you discover new information about any possible, for example, like if they've ever applied and disclosed before, but they've disclosed it now to you, to make sure that you reach out to your Her Justice mentor to talk about your specific case. So what do we look at in the inadmissibility analysis? Basically, you want to determine what grounds apply to your client's case. And then you would look at whether or not those grounds can be waived. In the U visa context, the waiver available for U visa applicants is pretty generous in terms of like other types of immigration relief, in that the only grounds that cannot be waived are if they are a Nazi, committed genocide, or any sort of extrajudicial killing or torture. There's no waiver available in those situations. You would have to show favorable discretionary factors, that USCIS should exercise discretion, and that your client should be granted that discretion. And so what that means is you want to collect as much positive information to show that your client is should be granted that. There's one pull. And the form that we use for a waiver is called an I-192. And that means that application is called an application for advance permission to enter as a non-immigrant. And there is a fee with that application, but there's also a fee waiver that you can file as well. Okay. Okay. So let's look at Gladys's case. Does Gladys need an inadmissibility waiver? Yes or no? Thinking back to some of the things that were described in her hypo about how she entered the US. There should be a poll. And just give a couple seconds more. Okay. So it kind of jumped a little bit ahead, but first, based on what we described, does Gladys need an inadmissibility waiver? Yes or no? So based on what was described, she entered the US, was stopped by immigration officials, returned to Mexico, and then re-entered again. This time, the second time, she wasn't apprehended. So yes, she would need an inadmissibility waiver for entering without inspection. And the second, kind of just to add to her hypo, was like, what if she used a fake passport to enter? That she would also need to file for a waiver because she used a fraudulent document to enter the US. Okay. And then finally, what if she was arrested because of abuse? I don't know if there's a polling option for this. But basically, this would be a trick question, because if she was arrested because of the abuse, the way that the question is worded is if she was arrested, if she was convicted of a crime because of the abuse, or a related, if the police were called and she was also arrested and convicted, she may need a waiver. But if she was just arrested, there's no conviction, so there wouldn't be necessarily a need for a waiver in that case. Okay, so what are some considerations for waivers of inadmissibility? Like I had talked a little bit before about providing like that USCIS, you want to provide materials to show that your client is deserving of this exercise of discretion. So basically you want to show that the risk of harm to society is very low, that for the most part, this is just generalized obviously, but most of the clients that we place need a waiver because of entering without inspection, or for kind of not just immigration violations, so that we argue, you know, that that's the only contact, or is that the crime is very low, like the harm is very low, and that there's the reason that they're seeking admission to the US. So in most cases, they want to stay here so that they can continue to raise their children, to provide for their families, and that it may provide hardship to their US citizen family members. Oftentimes, the clients are very connected in their communities, in their place of worship, different types of community ties that they may have. And you want to talk to your client and highlight all of these things so that you bring these to light and show that these are the reasons your client is deserving of an inadmissibility waiver. So in Gladys's case, we see that, just to highlight some of the things in her case, that her abuser, Miguel, is undocumented. After the prosecution of the crimes that he committed against Gladys, he was removed to his home country after the criminal case. Their U.S. citizen child has special needs. Their child here has a seizure disorder. Gladys is from a poor rural area, and that her child and mother in Mexico rely on her income for basic necessities. So what could we argue here for Gladys's case? I think we would want to highlight her U.S. citizen child and the fact that they have special needs, so that they may not be able to access the same kind of medical treatment if Gladys was forced to relocate back to Mexico, that she has no criminal convictions, and that country conditions in Mexico would adversely affect what that beeping is. But we would also want to highlight possibly that her abuser was removed back to his home country, and that if she were also to be removed back to Mexico, that he may be able to, access her and continue abusing her, and she would be less likely to benefit from the order of protection she would have here in the U.S. or different types of protections that she's able to access here. So these are kind of what we want to address in her waiver application. And so what types of evidence do we use in the waiver application? Aside from the form I-192, we would want to craft the client's sworn statement, so an affidavit, and documentation showing her child's medical treatments, that she received certain treatments that are available to her here. You may want to see if there's any support letters you can collect from family or friends or community members, and other statements from family or friends here addressing the hardship to her U.S. citizen family members. So these are just kind of some ideas of what you can ask your client to see what you can put together to provide more support for the waiver application. Next, we're going to talk about what oftentimes is one of the most important things to our clients is any qualifying members that they may also be able to help get status. And so who is a qualifying member? A qualifying family member depends on the principal petitioner. So if your principal petitioner is under 20 years of age, they are eligible to apply for their spouse, children, parents, and unmarried siblings under the age of 18. If your principal petitioner, so your principal client, is 21 years and over, they are only able to petition for their spouse or children. Okay, so in Gladys's case, she's 27. Who would she be able to petition for? So she would fall into the second box. So only her spouse or children. She's not married, but she does have her son living abroad in Mexico. He is under 21, so he would be eligible to be applied for. If she were to get married at some point before her application is filed, she would be able to, and that person is undocumented, they would also be able to benefit from a derivative application. And so there's different timings for derivative applications. They can be submitted concurrently or after the principal's application is filed. The main thing to remember is they cannot be approved unless or until the principal's application is approved. There's also no statutory cap to derivative applications, so there is no number limiting how many derivative petitions can be approved, only principal applications. And so what are some ethical considerations we want to take into consideration if you're working with a client that has derivative beneficiaries or potential derivative of a principal or derivative beneficiaries applies different duties to that are owed to both the principal and derivative. So you still have to maintain the duties of loyalty and confidentiality and acknowledge that there's potential that conflicts of interest can arise later. And so you want to discuss that with your firm and include that kind of language in an engagement letter or the retainer that you will be signing with your client. This is just another graphic from that account, and is that it's also really important that that practice advisory that I talked to you about for the I-918 also applies to a derivative application. So to make sure to look at your Her Justice manual for sample forms and the sample practice practice advisory regarding blank spaces. It seems ridiculous, and it is ridiculous, but the USCIS has been rejecting applications based on leaving blank spaces or not correctly putting NA versus not applicable, or so make sure you look at that and discuss any questions you have about that with your Her Justice mentor, because having an application rejected can affect whether or not a derivative, like the timeline of your application, and whether or not, if you are working with a client that has a child that's turning 21 soon, or possibly aging out, to make sure you just double check and review that advisory. The form that you file for a derivative application is called an I-918A, and that is the petition for a qualifying family member of a U1 recipient. So a U1 is your principal applicant. And this here is just a page out of that form, and that there are manuals, there are samples in our manual and detailed instructions on how to fill these out. Again, you can submit drafts to your Her Justice mentor to have them review it, but that this is kind of just so that you can see what the form looks like. Most USCIS forms look very similar, but again, there's samples of all the different types that you will be working with in your manual. This is the next type of application that you would be filing for your client. It's called an EAD, the Employment Authorization Document. Here's another sample of what it looks like, and that this application that are present in the US, and you can file them under different codes in anticipation of deferred action, and that there are different codes that apply for derivatives and for principal applicants, but that, again, there's samples of all of this in our manuals, and there's detailed instructions. This is just to kind of just familiarize yourselves with what it looks like briefly, and an overview of what types of forms you'll be filing. The other important thing to note is that the inadmissibility waiver and the work permit application for deferred action and for derivative applications have a fee associated with them. And so most likely your client will require a fee waiver because the fees for each application are pretty high, especially if they're filing for multiple family members. In total, it may be like cost prohibitive, and they're also eligible for fee waivers. Confusingly, the form for the fee waiver is called an I-912, which is really confusing because the inadmissibility waiver is an I-192. But that requests for fee waivers are available for this type of application. You would likely file it with the form and some sort of supporting evidence of why they're unable to pay, in addition to an affidavit. Again, there's in the manual, there's samples and detailed instructions. This might be something you want to discuss with your client and your her justice mentor, because there is a little bit of a strategy on fee waivers, because they've been a little bit difficult to get approved in this current administration. And so you might want to discuss different options for applying for relief fund to have the fees covered, or strategizing about what type of evidence you can collect to show their inability to pay the fees. So again, there's samples in the manual and detailed instructions on that. So in summary, what forms will you be filing? If you're working with a principal and derivative beneficiaries, the forms are listed here. The I-918 is the U visa form. The I-765 is the work authorization form. An I-918A is if you have derivative beneficiaries. An I-192 is if your clients need to waive any inadmissibilities. And an I-912 that have a fee. That's the fee waiver application. Okay. So what is the timeline of a U non-immigrant status? This is kind of going to be a little bit different this summer because everybody's program is, the timeline for everyone's summer associate program is a little bit different, but essentially the first thing you would do is call your client and set up an appointment. I think it's really important in that first meeting to kind of describe a little bit about what you are going to file with them and kind of give them kind of like a heads up of what to expect. So, and I would do this before every appointment. So if you're going to be working with them to get information for their affidavit, let them know that you may be talking about difficult things and that, you know, so that they can kind of mentally prepare that this conversation is going to be happening, and prepare themselves however they feel like they need to be. Your first appointment should also be the appointment where you sign the retainer with your client. You can work with your firm on how to do that logistically, whether it's a digital retainer or mailing it and having them sign and send it back to you, but that you want to explain the process to your client and give them like a tentative working time frame so that they know what they're going to need to do in the number of weeks that you are working with them. The next is the clients are always going to ask you the timeline for their application. And especially for U visas, it's really important to manage their expectations of what is involved. So the first thing you're going to be working on in terms of just the immediate expectations of working together to file this form. So you want to explain to them that you're going to need to interview them and possibly have them give you names for supporting affiants that either they can contact or you can contact, however they feel comfortable. That you'll be working together to gather evidence, that you'll be working together to prepare oh, sorry. Okay. That you're going to be filling out the forms and the necessary waivers, and that this case has to be filed within 6 months of that certification being signed. So depending on how long ago your cert was signed, you may have 5 months, the full 6 months, or a shorter period of time. And just so with that in mind, the client can kind of manage how often you'll have to meet and understand that you're doing all of this within a time frame to submit their application. Also noting, I wrote here, file with VSC. The office that within USCIS that U visas are submitted to is the Vermont Service Center. And again, those samples are all in the manual. Once an application is filed, again, this is working under the assumption that USCIS and the local offices in New York City will be reopening with some sort of schedule for this, because they've been closed for the last 3 months, but are scheduled to reopen this month. Once an application is submitted to immigration, any kind of application, the client will then be scheduled to have their fingerprints taken, and that's called a biometric, and it's usually within a month of filing the application. The petitioner and any derivatives over the age of 14 must appear at a local USCIS office to be fingerprinted and photographed. If they have derivatives over the age of 14 abroad, you'll receive a notice describing how to arrange for them to be fingerprinted at their local US embassy or consulate. When you receive that notice, make sure to contact your Her Justice mentor for country-specific instructions. So depending on where they are, it'll determine how to go about scheduling that appointment and whether or not they can do it themselves, or if it's easier for you to do it for them and send them the documents digitally or physically. And then once the application in this case is filed, it's usually pending for quite a while because of, again, the cap. It can be at least a 4-year period. And so at any point in that 4 years, you may receive, or the firm would receive something that's called, it's possible that they may receive something that's called a request for evidence. And that's short called a RFE. And that once that is received, that the firm or immediately, because it's usually a notice from USCIS with a response deadline, and they are asking for more evidence or asking for some sort of clarification on the elements or requirements for the U visa, and they may require a new certification. It could be more like a more detailed affidavit about the qualifying crime. It could be a number of things, but that there is a timeline for a response, and that you should reach out to your Her Justice mentor as soon as possible. The other thing to note or to let your clients know, that once their application is filed, it's really important that they stay in touch with their attorney and the firm that's representing them, because if they have changed their phone number and address and haven't had contact with you in 2 to 3 years, and you receive a request for evidence, you're going to be wasting a lot of time trying to contact them and losing out on time that you could work on their request for evidence. And potentially, if you've lost contact completely, they will have lost out on their eligibility for a U visa, because you have no way of getting in touch with them. So it's really important that if they do change their number, to make sure that they let you know, and that is very important to their case. Okay, and then at some point, again, timeline is an estimate, they will be issued a letter granting them deferred action. If at the time you file the initial application, you didn't file an application for a work permit under the category C14, which just means that you've received deferred action. You can apply, you must apply for a work permit at that point so that they can get a work permit. And also the work permits under deferred action right now are being granted for 2 years at a time, with the idea being that at some point within those 2 years, they will have a visa number available to them and be granted their full U non-immigrant status. And so also to note for the firms is that you can contact Her Justice once deferred action has been granted, and that there's an optional termination of your representation of the client at that point, and the case can be returned or placed again with Her Justice. Okay. Will Her Justice assign summer associates to new cases only, or is it possible that a summer associate will be assigned to continue working on a case further along the timeline? As far as I know, for this summer, you'll be placed a new case so that the client has just the 918B, the cert, and you'll be working on all of the forms that I discussed before. So the 918, the I-918, the possibly a waiver, work permit. So it wouldn't be further along for a U visa case that's placed during the summer. Okay. And then this timeline is what happens after the wait list. That, it may be approximately 8 to 10 years after filing, estimated right now, that their case will be pending, but that for a U visa case, there's no interview for the U non-immigrant status. Everything is submitted on papers. That's why everything that we discussed is so important in being detailed in your affidavit, and making sure you demonstrate or make sure that all the evidence submitted shows that they are eligible for and meet all the requirements, because there is no interview or anything in person there's no interview or any other opportunity after that. If granted, USCIS would issue a U non-immigrant status and work authorization that's valid for 4 years. So the period that they have under their U visa is for 4 years. And that if you do receive a denial notice, there's usually a time period of 33 days to appeal that decision. And this is all really important because these are the questions that most of the clients are going to ask, like how long are they going to be able to wait? When are they going to get their green card? How long are their family members going to be at, or how long will it take for their family members to be able to come here? And it's really important for managing the expectations for the client so that they're clear throughout the entire process that this is a long time, but that ultimately after their U visa is approved, they are eligible to apply for a green card after 3 years of their approved U visa status, and that you should note the expiration date of their U visa status on their work permit and on the approval notice. It'll give you the 4-year period that they have been to note the expiration date, because if they do not apply within that time period for their green card, at the expiration date of their U non-immigrant status, they will once again fall out of status and not be able to get a work permit or anything like that unless they've applied for a green card. Also, after a U non-immigrant status application is approved, their derivatives abroad are eligible for consular processing. And you don't have to explain too much detail about this to your clients, other than noting that it's a different process for their derivatives abroad than it is for them here, because they have to go for an interview at the consulate, and it's just a slightly different process to be able to come here on their derivative application. And just to note that they should make sure to apply for their green card after the 3 years of their continuous period with their U status. This is another issue that's really comes up a lot with clients, is travel limitations for you non-immigrants. Let me just take a moment right now to give you the second CLE code. It's ICIBZ. Again, the second CLE code is ICIBZ. Okay. The travel limitations for you non-immigrants. Essentially, there's always been a risk for people trying to travel without a more permanent green card status, because as you've seen in recent times, there's various things that can happen that can close immigration, close people from being able to re-enter with permission or without permission, and all of this will affect their eligibility for adjustment or for a green card application. So like the most recent example is during COVID-19, if anybody had traveled outside of the country, right now a lot of countries have closed their borders, and so nobody's been able to re-enter unless they're a citizen or a green card holder, depending on their status, and that any absence greater than 90 days during the time that they have their U visa status can prevent them from being eligible for applying for a green card, and that there are certain inadmissibilities that do not trigger until you leave the country, so that a departure could trigger one of the have been living in the U.S. Without permission. They may be barred for 3 to 10 years, so that there's a risk always for traveling, even when their U visa is approved, or especially when their U visa is approved, and that it's really difficult to explain this to clients because they have been missing their family abroad, missed out on a lot of important events in their families' lives, their children that are abroad, you know, people that are important in their lives passing, different things that are really painful that they have been waiting to go be able to visit their family members, and that it's always kind of an individual risk assessment, and that you should always advise them to contact you before doing anything, and that to reach out to your justice mentor to discuss each individual case. But this is an issue that comes up a lot with the clients. And I guess before we end, just to see if there's anybody that has any questions, or to put that into the chat.
In the Q&A, please.
Oh, sorry, in the Q&A, sorry. Like, I can't see, oh, here they are.
Can you see them now?
Yeah, thanks.
Okay. We'll just do the one at a time?
Yeah.
Great.
Okay. Our summer associate program is only 4 weeks. Is it advisable to take one of these types of cases considering the long timeline? So the case, usually what would happen with your firm is that it will be assigned to an associate, and so that whatever you're able to accomplish during the time of your summer associate program will be kind of primarily dedicated on working on the affidavit and the forms, and that once you end your summer associate program, it's reassigned to an associate or a partner at the firm, and they will kind of track the case going forward. So yeah, it's totally, the timeline of 4 weeks is, I think it's a doable time period to get a lot of this work done, because you'll be able to work with a client on her affidavit, prepare the forms. So yeah, I think that that's a totally workable time period. Okay, let's see next. Mayan asked, can an expired 918 cert be recertified? Yes, it can be. We generally try, the cases that we will place have they're not expired, and there are sometimes where things come up and that a case may be advisable to ask for a recert, but that generally we try to file, we advise to file it within that time period. But yes, depending on the agency, you can get a cert recertified for various situations that that you weren't able to file. You can we would help you contact the certifying law enforcement agency and ask them to reissue it. Kevin asked, are derivative family members abroad allowed to come to the U.S. once deferred action has been granted, or only after the U visa has been granted? So they are only, derivative family members abroad are only able to come to the U.S. once the U visa has been granted. The time period or while the case has been granted deferred action only benefits family members and the principal that are here in the U.S. So the client that's here is able to get a work permit during the main benefit of deferred action is that the client and any derivatives in the U.S. are eligible to get a work permit. But any family abroad, the process for consular processing to come to the U.S. is only started once the application has been granted. Is everything in these slides covered in the Her Justice Manual? Yes, everything is addressed in the Her Justice Manual. So the forms, detailed samples that are like filled in, breakout, and all of the materials and resources for working remotely. Those are all in the manual also. Does anybody have any questions about working remotely with clients? Because that's something that we all have been thinking about a lot, because we've never done it before. But if you have any questions about contacting your client or figuring out how to talk about these things remotely, feel free to pop that into the Q&A also. Okay, on the screen right now are just some resources for all the forms that I've discussed. You should go to uscis.gov and type in the form numbers and download them from the USCIS website to make sure that you have the most recent version. Everything that's in the manual is up to date as of right now, but you should always go there and check, because every so often USCIS puts out a new edition of the form, and so that there's timelines for when the old forms will still be accepted and the new forms. Again, this is stuff that you can talk to your Her Justice mentor about, but if you think that your client may have been in immigration proceedings before and they have something that's called an A number, it's a 9-digit number, kind of like a social security number, but for immigration purposes, that 1-800 number there is an automated phone number where you can enter in the A number and see if they've had any contact with immigration court before. The VAWA hotline right now, it is, we're not sure if it's being staffed right now because of the COVID-19 situation, but that's a number that you can call if you have any problems with once your application is pending. And there's also a VAWA unit email specific for U visas that's listed there. Oh, there's one more question. What do you recommend as a preferred method for remote client communications? So for that question, I would ask your client what they office, and with like internal meetings, we've been doing a lot of Zoom, but there's kind of also for yourself a level of comfort that you would want, and also it can be kind of invasive for a client depending on their living circumstances, and it's very personal to be like in your bedroom, sitting on your bed talking about these things, that they may feel more comfortable having a phone call so that you can't see like inside their home, or they can't see inside your home. But yeah, I would recommend talking to your client and seeing what they are comfortable with, because at the end, you're trying to get a lot of personal information from them, and you want to make sure that they're as comfortable as possible. Other times there's like a level of safety planning that goes into client communications when they can't come to your office. So is it safe for them to be in their apartment talking about these things, or do they have to make a plan for going for a walk or sitting in a park, so that they don't have other people that might be listening to them, or kind of if they are seeking services and they don't want family members to know. It's really a lot of different things that are taken into consideration for them. And I kind of was, when I was trained with working in this area of law, is like that the client is the expert on their life and their safety. And so just to check in with them, what they feel safe doing. Again, this is the contact information for all of the immigration mentors. You'll be assigned one of us depending on what firm you're with, but this is our contact information. You'll have it in other places too. And if there's no more questions, just to say thank you for picking a case from Her Justice and working on one of our clients' cases. Some of them have been waiting a long time to be placed, and getting the news that they've been placed with an attorney is life-changing for a lot of them. So thank you for taking the time this summer to work on a case. I'll just stick around a couple more seconds or minutes if anybody has any questions. Mike, I don't know.
Yes. So you're going to receive a couple of things. At the end of this webinar, you will be directed to a survey via SurveyMonkey. Please fill that out, and please do your best to answer all the questions. I will also be emailing you our volunteer info sheet for SAP, specifically for summer associates. So please fill that out as well. It's not just for people receiving CLE credit. This also helps us when shaping our webinars and our trainings. So definitely please fill both of those out. If you have any questions regarding the trainings, again, these will be recorded. And if you have any trouble accessing any of the materials, please let me know. Anything else regarding the law in your case, definitely feel free to reach out to Prathiba or Esther. So yeah, so if you have any other questions, please reach out. Thank you very much. And Pratibha, I'll leave it to you.
Thanks, guys. My email, again, if you guys have any other questions that you think of later, you can either feel free to email me or any of the other mentors that are listed here. But if you have a case or a question about a U visa, feel free to email me. There's no questions. I think we're